Shona Minson is a British Academy Research Fellow at the Centre for Criminology at the University of Oxford. She's from Belfast originally, and after studying law at Oxford and being called to the Bar of England and Wales, she practiced criminal and family law in London. Her academic work explores the intersection of crime and family, and in particular, the rights of children whose parents are in conflict with the law. Recent research projects have focused on the sentencing of mothers, the pandemic lockdown experiences of children with parents in prison, and the barriers to participation in family court proceedings for mothers in prison in England, Wales and Scotland. We are delighted to welcome Shona Minson to talk about prison sentences for women, negative consequences and non-carceral alternatives.
I'm really glad to be here. I was expecting to just be sitting, being a participant, and got I'm a shoe-in for another speaker. So a little bit more to do than I was expecting, but I'm really glad to be here and talking to such a diverse and interested group about these issues. So I'm going to talk about the disruption of women's imprisonment. First of all, the disruption that it causes for children and for justice, and then after that, the ways in which it can be disrupted, and I've put for good and for the future. So I'm going to begin with the disruption of women's imprisonment for children. And I think there are some people in this room who, having looked at the attendees and knowing, are real experts in this. And I know there has been a lot of work done on this by the Irish Penal Reform Trust and others. But there has been a growing understanding since I came into the field about 10 years ago of the fact that actually imprisonment doesn't just harm. It's not a binary process. We're not just talking about the person who is in prison and perhaps their victim or the state. Those tend to be the people that are thought about whenever we think about punishment. But actually the ripple effects are huge. And I think we're only starting to grapple with really how huge they are. And it might be helpful for you to know a little bit of how I came to start thinking about this, which was that as a family barrister, I was very used to doing care cases where children were removed from their parents by the state because of abuse, harm or neglect, or the likelihood of. And it was for protection for the children. And the children there was no level of wrongdoing with the children. And if there was blame, it was attributed to the parents. And the state would deal with those children in a particular way. And when I started doing, it was actually a master's in criminology, criminal justice and social research methods, because I thought I was going to work in some sort of penal reform organisation, and I knew about advocacy having been a barrister, but I knew nothing about social research. So that was what I was trying to put together. But I started looking at the data on women who were in prison, and I was of course thinking, well, what's happening to their children? Because I'd done care cases and I knew what happened to children when they got separated from their parents, and I couldn't find any research evidence on that. And that was what set me on the course of being a completely accidental academic and doing a PhD and still being here 10 years later, because it seemed there was quite a lot of work to do. So when I began my work in 2012, there was no research evidence on what was happening to children when their mothers went to prison. We just didn't know. And from the work I was hoping to do to talk to judges about their sentencing, you can't say to a judge, well, you must take this into consideration. And they say, well, what am I taking into consideration? Where is the evidence about any harm that people are suffering? It doesn't exist. So how can I possibly factor that in? So what I began by doing was finding children whose mums were in prison and talking to children at the time of their mother's imprisonment. Most people, if there was anything written about this, it was from either the mother's perspective or adults saying, we think this is what happens to children. But as any of you who are involved in work around children, they have rights. They have a right for their voice to be heard, and that means actually talking to them and understanding their subjective experience. So I'm just going to start with a little bit of the research findings from back then. So short-term impacts on children cover every aspect of their life. It affects their well-being, future outcomes. It's a physical separation from often their primary carer, change of home and carers. Certainly in England and Wales, it's thought that about 90% of children whose mothers go into prison have to move home because their mother has probably been the primary or sole carer for them. They move into increased poverty because often whoever they live with is in the same sort of socioeconomic demographic as their mother was, and we know that women in prison tend to be from lower socioeconomic groups. Their education is disrupted. They suffer social isolation. The changes in the parent-child relationship affect their future stability. They have a lot of difficulty visiting mothers for various reasons. We see a lot of changed behaviours, and I came up with this term confounding grief to try to describe what I was hearing from the children, because all of them were sad. That, grief was part of their everyday. And it seemed to me it was for two reasons. One was the sadness at the loss of their parent and the confusion that brought. The reason I called it confounding was because their whole expectation about their life had been confounded. They had moved home, they had maybe moved to schools, they didn't see their parent anymore. There were all kinds of things that they didn't think would happen in their life. But also their grief confounded everybody around them, because we do not understand how to respond to people who have a family member in prison. There is so much stigma attached that, if you think of a situation where a child's parents maybe separate, or a parent dies, or even a parent is serving with forces abroad or something, we know how to deal with those children. At school, they'd be given extra attention. People around would make sure they got included in birthday party invitations or whatever it was. People make special efforts, not with a child whose mother goes to prison, because people are horrified. They think, well, this child, maybe they're a problem as well. So children find themselves excluded because of this. So that confounding grief is a huge part of it. I am sort of very much, all of what I say, I'm trying to fit a lot into my 40 minutes. So it will be quite surface level, but please come back with questions at the end. In terms of longer term impacts, work by Mears and Siennek in 2016 talks about turning points, trajectories that take a different turn at some point in someone's life, and really there's no way back from it. You're never going to be back on the same path. And parental imprisonment is recognised as being a significant turning point for a child. They are less likely to be in education, training or employment in later life. They're more likely to have mental health and addiction problems, and they're likely to earn less than their counterparts aged 30. Now you'll see some of those references go back a long way. There's a lot that has come much more recently, but this is not a new problem. We're just only starting to pay attention to it and identify it. There was a study came out of the Netherlands in 2018, because they have fantastic data on imprisonment and following people through, and they found that children who experienced parental imprisonment were more likely to die before the age of 65 than their peers, and that's increased if it was the mother who was in prison when they were a child rather than their father. Now we don't have we can't say the reason why maternal imprisonment affects more is because, but there are lots of possibilities as to why that is. But I think that's a really sobering piece of data. So when we think about the impacts of maternal imprisonment on a child, they are not short term, they're not even medium term. They are lifelong, and they may well shorten their life expectancy. So we can't pay too much attention to this. It is so important for children. Another thing that I think is really important to just hold in our minds, and this came out of the research that I did during COVID. So this was during the first lockdown. I was very conscious that this group of children who are already quite traumatised were going to go through an even more traumatising experience. We all found the COVID lockdowns pretty hard going, but if you were a child with a parent in prison, that had layers of trauma attached to it. And so I did this piece of work, which I actually had to bring to an end slightly early because I was finding it too difficult to manage as a researcher, because what I was hearing that these children were experiencing and the impacts that was having on them was sort of way beyond what I've ever heard before. 7-year-olds developing eating disorders and self-harming and all the rest. Because for them, not seeing their parent, they were worried about them, but they also were interpreting that as, I'm not loved anymore. That was really fundamental. And the governments weren't interested in doing anything about it. But back to this picture. What I discovered of the families I was talking to at that time was that 53% of them were on a household income of less than £15,000. And you see the next group up is another 28% were on less than £25,000. Now that puts those people in what we describe as poverty. And so got to remember as well that the families and the children we're talking about are often in the most difficult circumstances for lots of other reasons as well. And the imprisonment is intersecting with that and also increasing the difficulties of those. We know that money is a buffer to so many things, but actually these children do not benefit from that buffer at all. So we come to the really key question: is this impact on children relevant to the sentencing of primary carers? And should the courts be involved in addressing it? Now, for those who say no, the arguments tend to be these three, and I've heard them a lot. The first being it's unfair to those who don't have children to take it into account when you're sentencing. So why should somebody have a non-custodial sentence when actually if they didn't have children, they would go to prison? The next is saying, well, the criminal court's not a welfare court. It's not for that court to look at these social circumstances. And they did the crime, they have to do the crime. She should have thought about the children before she committed the crime. Those tend to be. And I could happily offer rebuttals to all of those, but I'm not going to spend my time doing that now. I think there are some easy yeses that we can focus on. The first is that social situation is always relevant. Sentencing is a discretionary exercise. And so every day, judiciary are thinking about the context of the offender and the context of the offence. And that is how they reach their decisions, certainly in our jurisdictions in England and Wales and in Ireland. And so it's not a new thing to say to sentencing courts, you need to be thinking of all the circumstances in this case. They already do that. That's part of their job. That's what they're trained to do. In England and Wales, the sentencing guidelines and case law actually require this kind of thinking, and they have done for years. So when I started my research, I was looking back at the case law, and there was a case from 2001 that Lord Phillips had said, you've got to, this is the most serious thing we can do is to separate a parent and child. You must balance these things. And I went to interview him, and he said, well, I made that decision in 2001, surely everybody's following it. And I had to break it to him that no, they were not. But we have this long-standing body of case law that very clearly says, and has built up over time, saying we have to weigh this important factor when we're sentencing a primary carer. And since 2011, it has been it's a factor that can be considered in mitigation, is that someone is the sole primary carer for dependent relatives. In Ireland, there is the overarching thing is proportionality. And again, circumstances come into that kind of balancing. So already the courts, yes, they should be involved in addressing it. And they've already put themselves in a position where it is part of their remit. When we look at, from child rights perspective, which in Ireland, I think because constitutionally law is working differently, I think the UNCRC is sort of more often referred to. In England and Wales, it's not really something we like to talk about. And so the judges were not really thinking about what the rights of a child are under the United Nations Convention. But it says, particularly importantly in Article 2, that a child has a right to non-discrimination. And that includes discrimination or punishment which they suffer because of the status or activities of their parents. So if we treat children differently because their parent has been convicted of a criminal offence than we would treat any other child, that is procedural discrimination under the UNCRC. Their best interest should be a primary consideration in any decision concerning them. They have a right to be heard in proceedings concerning them, the right to special protection and assistance if separated from their parent. And in the UK, we've got the Human Rights Act, gives the right to family life and the right to enjoyment of rights without discrimination. In my work, because I was coming from a family law perspective, I was thinking, well, what, as I said at the beginning, what happens to children when they're separated in a different forum? And the Children Act 1989 says the best interests of the child are the paramount consideration of the court in any family law proceedings. And the court would consider a welfare checklist to think about a child's well-being. They would take into account the child's wishes and feelings. The child will be represented by lawyers and a guardian ad litem who are paid for by the state, so they have their own representation in the proceedings. And if they are separated from their parent, the state will assess and fund and support alternative caregivers for them. So we have this whole system set up in the family law to recognise that actually when you do separate a child and parent, there are all kinds of disadvantages to that child. And the state has stepped in to try to build a support around that. So yes, disruption is addressed in the family court. And that was the tool that I essentially used, or the framework, to try to draw attention to this issue in England and Wales. And the way that I did that, I'll just very briefly, was after I'd finished the research and found these things, and found that judges were not taking into consideration the case law and the sentencing guidelines, and they did not have an understanding of the harms to children, which meant that they were not making sentencing decisions in the way that they already had said they would. So there was a gap there. And the other issue was within, I suppose, other departments, the Department of Education, the Minister for Children, all those other people were not really thinking about this group of children and their disadvantage. And so I went to the Joint Committee on Human Rights and asked them if they would hold an inquiry into the rights of children whose mothers go to prison. And it was a bit of a process, but they agreed to hold the inquiry, and they did that in 2019 and got lots of evidence from various government ministers and other groups. And they found that indeed these children were suffering procedural discrimination because the courts were not considering in the way that they considered children in the family courts. And then it made a lot of recommendations about sentencing, about their treatment during the time that their parent was in prison, about data collection, because we don't have any, so we don't even know how many children are affected, and all those kinds of things. And that was very helpful because it drew a line. We didn't have to keep arguing about whether these children, whether their rights are being upheld. It was declared by the Human Rights Committee they are not, and that the UK, England and Wales were in breach of that. They made recommendations to the government which haven't been acted upon, but you take it slowly and maybe we'll get there. One of the things that did come out of that, though, was that the Sentencing Council, in a new guideline, overarching principles, gave an expanded explanation for the sole or primary care of dependent relatives. And they've actually just put out a consultation on a revised version of this guideline to try and embed this even more. But I don't know if that's too small for you to see. But it essentially took all the principles that were already in case law, so things like they shouldn't impose a sentence of imprisonment where the impact on dependents would make a custodial sentence disproportionate to achieving the aims of sentence. And they needed to consider suspended sentences, they needed to consider, children even with a community sentence. There was stuff about pregnant women. They needed to make sure somebody actually made arrangements for the child before they sent the mother to prison, because that was happening quite frequently, that someone goes to court, end up in prison, and the children are left at school, and it's only whenever the mother doesn't turn up that they discover what's happened, that actually that shouldn't be happening, and that the court should be getting pre-sentence reports for every primary carer before it made a sentencing decision. So that was great. That put it into the guidelines. Unfortunately, it was several clicks through on the guideline website, and so it hasn't been used in the way that it perhaps should. But there have been Court of Appeal decisions on this which have... there was one in Attorney General's reference, which is when the sentence is thought to be too lenient, where a mother was given a suspended sentence because her co-defendant, who was the father of the child, was given a custodial sentence. She was given a suspended sentence, and it was referred up for leniency on the basis she should have gone to prison as well. And the Court of Appeal referred to this stuff and said, no, that was the right decision to make. So it's helpful that we know there is an intention, certainly from the Court of Appeal, that the impact on dependents should really be considered at this level. The revised guideline will hopefully make it not 3 clicks through to get to this, and it will be part of something that every judge sees every time they go to sentence. So possible additional next steps, and I'm just sort of throwing this all out here for you to think really about the Irish context and what might work and what is missing and what ways can this go in. One option is the government in England having a statutory duty, saying that courts have to consider the best interests of a child, and that would be a kind of one-line piece of legislation. There's a lot of debate about that, about quite how you balance best interests of a child against everything else. I think it would be appropriate that we have a statutory duty saying it must be considered. It's not saying it's going to outweigh everything else, but it must be considered. And the other thing is we've got this Section 17 of the Children Act, which identifies groups of children who are children in need. And what that means is that local authorities have to assess what their need is and provide any support for that child to thrive. And at the moment, children with a parent in prison are not included in that group. And I think they probably should be. But that is more about what happens once you've decided to put the mother in prison rather than going further upstream and avoiding those sentences in the first place. So that's a bit of a whistle-stop of impacts on children. The project that I'm working on at the moment is thinking about procedural justice for women in prison, but also thinking about how that impacts their children and those children's rights. So slight gear change here, and we're at Article 6 of the European Convention on Human Rights, which says that in the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. So what does this mean? People normally think of it in terms of criminal proceedings, but it includes civil proceedings as well. So it means that you've got a right to adversarial proceedings, you have a right to equality of arms, a right to the appropriate administration of evidence, and a right to reasoned judicial decisions. And I just, wanted to give a little bit more detail on this, but maybe I don't have it quite in front of me. The two things I've been focusing on, or the main thing I've been focusing on in this study, where I'm looking at the right of women who are in prison to take part in family justice proceedings concerning their children. So those proceedings that have either been ongoing before they've gone into prison or have started because they are in prison. Are those women actually able to participate? And the participation rights here are the right to adversarial proceedings, to be equipped to take part in those, to be given, to be served with papers, to understand that proceedings are going on, to be able to be represented or represent yourself, and that you have equality of arms. So we've both got the same sort of heaviness of sword to fight with, is what we're talking about in this, that there is not a power differential. And looking at the family courts in England and Wales, they set out in their overriding objective that they want to enable the court to deal with cases justly, having regard to any welfare issues involved. And then they say dealing with a case justly includes, so far as is practicable, ensuring that it is dealt with expeditiously and fairly, dealing with the case in ways proportionate to the nature, importance and complexity of the issue, ensuring the parties are on an equal footing, saving expense and allotting to it an appropriate share of the court's resources, whilst taking into account the need to allot resources to other cases. So that's from 2010. So it's clear that already our family courts are saying, yes, we want people who appear in front of us to have this equality of arms. Obviously, cost is still a consideration, that's in there, and that they've got to think about court time. But there is an intention to do that. And then in 2017, there was an addition to this that came out about vulnerable people in court proceedings. And that was really about providing protection support for people who have been victims of domestic abuse who are involved in family proceedings. So it focuses very much on how you allow somebody who is coming into the courtroom at a disadvantage to feel safe in that space and to participate effectively. So that has, they can put special measures in place that could include somebody being behind screens or on a video link or not having to face questions from the person who has abused them or those kind of things. But the list of vulnerabilities do include things like their domestic situation and location and ability to take part in proceedings. And to me, that seems to be relevant for people who are in prison, because they are in a very different sort of space to take part in proceedings than anybody else might be. And so I wanted to look, knowing that the intention is there, knowing that there is a right to a fair trial, what does that look like? So I've been conducting a comparative study in England and Wales and Scotland, these two jurisdictions, to see what happens. And I think that they've got very different legal systems, so there's a lot of difference. And again, I'm just going to be skimming over that at this point. But one of the things, and I don't know what the situation is in Ireland, so I'd be really interested to hear. In England, there is no legal aid for private law family proceedings. So between just parties themselves. So I go into prison and my partner or ex-partner stops bringing the children to see me, and I want to go to court and ask for an order to be made so that there is contact between me and the children. I can't get legal aid for that if I'm in England at all. The only time you can get it is if there is evidence of domestic abuse. Now that can be quite hard to prove. And in order to get legal aid, you also have to provide a lot of financial information. So that again is a very difficult thing for somebody in prison to produce. You do get legal aid if the state are involved, so if it's care proceedings, then parties are entitled to legal aid. But again, there is this proof of finance needs to be done. And I've been looking at case notes from the social workers in a couple of women's prisons at the moment on a pilot. And it'll be, the woman has 3p in her bank account and gets paid £8 a week in prison, but has to produce bank statements. And actually, how does she make those phone calls to her bank? When you phone a bank, you sit and wait for however long. If you've only got a certain amount of PIN credit on your phone, you're not going to use it to sit on the phone to a bank. So therefore, you can't produce your financial documents. Therefore, you can't get legal aid. Therefore, you're not represented. So that sets us up with a lot of barriers to begin with for women in England and Wales. In Scotland, they do have legal aid available for those kinds of family proceedings, and that makes an enormous difference in just allowing people to even be at the almost the same starting point before they get going. Whereas in England and Wales, it's like we put somebody, a kilometre behind where the start line is to begin the race. So just very briefly, talking about some of the barriers that I've come across. In terms of participation, I've given it 3 Ps to help me remember: preparation, presence and prominence. In terms of preparation, so there is a lack of information, both practicalities and content. Women often don't even get served with notice of proceedings. So they don't know that court proceedings regarding their children are taking place. They often then don't get the documents, even if they've been served with notice, they don't get the papers. Quite a lot of women can't read. And so if they get served with a 100-page court bundle the night before proceedings, that is of absolutely no use whatsoever to them. And all it does is create enormous anxiety and stress. They've got difficulties initiating proceedings, as I said, because if I knew that I needed to start court proceedings for something, say that contact situation, I would Google it. I would say, what do I do to go to court? In prison, you have no access to any kind of information. So unless somebody that you have contact with in prison knows and can tell you, you're just stuck. And most women are often told, you have lost all your parental rights now that you're in prison because you've committed an offence, which is nonsense, because parental responsibility can only be removed, certainly in England and Wales and Scotland, only removed through adoption. So women in prison still have the rights and responsibilities as a parent to do these things. And then they've got the difficulties accessing legal advice or legal information, because there are very few lawyers who offer pro bono work to cover those kind of private proceedings. And even if you're in state proceedings and are getting legal aid, it can again be difficult to get a lawyer to represent, just because of a shortage of people doing legal aid work. The second issue is presence. So you think it's pretty fundamental that someone should be able to attend their own hearing. But again, we miss the mark on that quite often, that women are not produced for hearings, either remotely or in person. And when they go to court, they may well, because they're coming from prison, have a prison officer either side of them, be handcuffed, be put in some sort of effective dock. So they're already being taken out of their own proceedings and treated in a different way. That obviously creates an impression to everybody in the room. If they're remote, then they are a head on a screen, and perhaps everyone else is in court. And when a woman goes into a remote hearing from prison, she will have been taken from whatever she was doing, placed in a room, may not know who is going to be on the screen when it turns on, what she's there for, why she's there. And what I hear mostly from judges is, oh yes, they don't say very much. which I don't think is a big surprise. So there are all kinds of issues there. They also have a lack of autonomy and a lack of choice and control about their participation, because it will be dependent on other people sending the right order to the prison, or the prison having the transport, or all kinds of things. And they also, and I can't say I don't want to go to that hearing, which anybody on the outside is able to do for whatever reason. And then the third one is prominence. So they get marginalised in their own proceedings. So although somebody may be a party, they may be the applicant in the proceedings. Because of all these other things around it, they end up very secondary to those proceedings. And I'm just going to jump a little bit into some theory here about why procedural justice matters. So what I find is that we don't have procedural justice there, but does that matter? Because actually, maybe these women would never get to see their children anyway. Maybe their children will never be placed back with them because they were not doing very effective parenting, and now they're in prison and they can't look after the child. So what's the point? Do we need to actually involve them in these proceedings? So we go back, social psychologists have said, yes, procedural justice, it's an instrumental good. It means that we believe our legal system is legitimate and people are therefore more likely to be law-abiding. Dignitarian theories have said, well, actually, there's a little bit more about the individual in that, and we need to take that into account. That's the kind of shortest summary you'll ever get of these theories. I'm not going very deep here. I promise there's more. And then what I am sort of using in my work is these relational theories that say, actually, procedural justice has normative importance. Whatever the outcome, it is really important that we do these things properly. And what we also have to do is recognise that certain groups have been oppressed and suffered inequalities and injustice already. And when they come into these systems, it's not enough to just say, well, we're going to do what we always do. You actually have to recognise the inequality already existing and put in extra effort and extra measures to raise people up so that they can then participate properly. And if we don't do that, then that is not procedural justice, if we're ignoring all of those inequalities. And I think that of many groups of people in society, people in prisons tend to be some of the most marginalised and oppressed through systems over time. And the way that we're doing it at the moment, I got this quote from a judge where he said, I think fundamentally there is a real problem in trying to ensure equal footing. And part 1 in the family procedure rules is very clear about that. I think he means that we should have equal footing. There are so many other areas within family proceedings where we always return to that about putting people on a fair footing. But I think you're prevented in achieving that when you have a mother or father in prison. So we've got a system where actually no matter how well-intentioned perhaps the judge is, it's impossible for them to manage this. And so that for me is sort of the shape of my work. That is another consequence of a sentence. So I look at the consequences of sentencing for children. They are ongoing. They go as far as then to these proceedings, to what happens next. And we know that it is in the best interests of a child, if there are proceedings about them, that both their parents have the opportunity to be involved. Whether or not that means they end up with the parent, the child needs to know at future times that their parents were fully involved and did all that they could in those proceedings. And so this is a child rights issue as well. Right, skipping on to the next thing. Disrupting women's imprisonment for good. Now, you can take that in many ways, but I want to think about how might we end this if we actually wanted to try to end it. And what has been tried in Scotland is a presumption against short sentences. And this began with a presumption against short sentences of 3 months or less, which, frankly, are ridiculous in anyone's book, because somebody's out in 6 weeks and what has happened other than you've entirely turned their life on its head, and you haven't done anything of any benefit to anyone. It was extended to 12 months. And they said, this was in 2019, those sentences are very disruptive. 90% of women are given a custodial sentence of a year or less, many of whom have experienced abuse, mental health and addiction problems. And the numbers are different in England and Wales and in Ireland, but the percentages probably aren't too different, actually, about who we're sending to prison for short sentences and why. And the then Justice Secretary, Hamza Yusuf, said that this is really important to ongoing work. But what's interesting, what I want to draw your attention to there is his last paragraph where he says, the presumption is not a ban. It really was an encouragement. And I think that's problematic. And I was at a really interesting webinar earlier this week where Professor Cyrus Tata from the University of Strathclyde was talking about this, where we say, okay, we don't want people to use short sentences. That should be a last resort. And, you know, as Hamza Yusuf said, it's not a ban, but we encourage you not to do that. And Cyrus was pretty straight and was saying, as long as we keep in that last resort thinking, they will keep being used. And the reason they keep being used is because we do not have the services in the community to support these people. And so it's sort of passing the buck to, as he said, individual professionals who are left to shoulder the impossible burden of chronic societal failure. So he was saying it's not fair to blame the judiciary for these short sentences. It's actually because we've got problems at other places and it gets passed along and nobody quite knows what to do. And because there isn't a ban, because we're still saying, well, you can if you can't think of anything else to do, it keeps happening. And what he suggested was saying, actually, prison should be justified. It shouldn't be alternatives that have to be justified. It should be imprisonment because it is so disruptive, it is so harmful. And his proposal was that it should only be used if it's warranted by the seriousness of the offending, and rehabilitation or help should be excluded as grounds for passing a prison sentence. Because we know, especially with women, that so often will happen that it will be thought, well, they've got a chaotic life, they've got addictions, they've got all these problems. If they go to prison, that'll be sorted. And whether that's true or not, it's not a good rationale for imposing a prison sentence. In fact, when I did research, the first bit of research I did with the judges, I had a judge who said to me, oh, I have no problem ever sentencing a pregnant woman because they'll go to Holloway prison and it's got the best mother and baby unit in the world, so it doesn't bother me. And I said to him, did you know that unit shut a year ago? And he was like, oh. So I think that there is often a lack of understanding. I don't know what it's like in Ireland, but in England and Wales, criminal judges do not have to have visited prisons before they are imposing sentences. So they do not understand what it is they are sending people to, and perhaps have this idea of, oh, it's good rehabilitation. So Cyrus was saying, let's set a target date where we're closing prisons, just say that's going to happen, our numbers are going to go down, and then shift the budget to community services. That's the kind of measure that is going to have to be taken. We can't keep leaving it open as an option. And then very finally, in my last 4 minutes, just talking about possible future, for women's futures, what are the other possibilities? Because actually, people who go into prison come out of prison, and we want them to have futures that are good for them and therefore for all of us. And I've recently got really interested in women's problem-solving courts. And so I'm just giving a very brief bit. I don't know if you know about these at all or how they operate. They sometimes operate for drug courts or for youth courts. And there are fewer for women, but I've been looking at 3 in Manchester and Glasgow and Texas. I haven't been to Texas, I've been to the other 2. They are all slightly different in the way that they work, and I've just set out some of the differences on this slide. But essentially they're for women who would otherwise get a custodial sentence, and they get referred to the problem-solving court. Now, in some jurisdictions, so Texas, they haven't actually been given a sentence, and if they go through problem-solving court effectively, they may never end up with a conviction. Glasgow, it's a deferred sentence, and so they can end up without further punishment at the end of it. And Manchester, they've actually already been given their sentence, and it's a way of supporting them through their sentence. But the idea is that there is an understanding, as I think Anna's presentation will probably talk more about, but many of the women in the criminal justice system have been through extraordinary trauma, have experienced abuse, exploitation, violence, homelessness, addiction, all kinds of things. And that actually, if all those I suppose criminogenic factors, homelessness, poverty, abuse can all be addressed, then they have less reason to offend because their life will actually have some stability and balance, and they're able to have autonomy and agency and find their way through things. And so the problem-solving court essentially creates a pause for somebody, and a supported pause, where although they are still within the remit of the court, they are being asked every month, How's it going? Have you got your housing sorted? Have you been checking in with your drug worker? What's going on here? What about a lot of support around reconnecting with children and getting children back into their care, which actually for an awful lot of women is one of the key issues that has caused them to spiral into offending. And so I'm at very early stages looking at these, but I think I'm just using them as an illustration of, I think there are all kinds of alternatives if we just were a little bit more imaginative. And the budget is there, it currently goes into prisons, but it could be used for all kinds of other things to much greater effect. And so I leave you with, I was involved in a round table in a conference in America where we had a woman who'd actually gone through the problem-solving court in Texas. And she had repeatedly offended, she had an addiction, she'd had 2 children already removed. She got to a point where she was arrested and she thought, this is it, you know, another long sentence. And for some reason, she was pregnant and she begged the judge, she said, please, can you let me do problem-solving court? And he said, well, why would I do that now? You know, you're a disaster, why waste our time on you? Somehow she managed to persuade them and they sent her to a facility for pregnant women. And she kept that child, she's been clean for several years, she works as a peer supporter, she's had the chance to turn her life around. And she said, why are we putting all of the money into something we know doesn't work? Why are we putting it all into these punishments? Why don't we just take the risk? That's a risky strategy. Why don't we take a risk in a different direction and put it into keeping people out of prison and then see what happens? Thank you.